Good morning. May it please the court, I'm Attorney Brad Harf. I'm here this morning on behalf of the appellant, David Stark. I'd like to start off with what I've cited as my third assignment of error. It's an evidentiary issue, and I think it's an interesting issue for the court, and I think it is the issue on which this case is going to turn. It's axiomatic, of course. Admission of evidence is at the discretion of the trial court. Under Evidence Rule 404A2, general evidence of the character of the victim can come in. In this case, that evidence was going to be offered by the defendant. Trial counsel for the defendant did object. He did make a proffer of the evidence on the record that the defense was going to present evidence about the general nature of the victim in this case, her actions, her becoming aggressive, and that evidence was kept out by the trial court, and our position is that was a reversible error. That evidence should have been admitted, and it would have made a difference in this case. Had the jury heard that evidence, possibly the outcome would have been different.
Yeah, of course, the state is alleging that the court was right because your client didn't allege any self-defense.
And that's what I think is one of the interesting parts of State versus Stringfield, State versus Homenai. It says self-defense or extreme emotional distress under reasonable provocation, which is an interesting phrase, and I would submit to the court that perhaps this court should address that particular phrase because I think it is met in this case. I would concede self-defense was not argued by the trial counsel, so that's not going to be the issue. I think the issue is going to be, was there that extreme emotional distress under reasonable provocation? What does that mean? And I think the facts in this case would support that that was present. The testimony was that Mr. Stark and Roxanne Matter, the victim in this case, have a child together. They don't have anything through the court establishing parenting time. And there are times when Ms. Matter doesn't let Mr. Stark see their child. And that was one of the catalysts on this occasion of what happened. It was an occasion where David Stark was going to see his child, and Ms. Matter said, "No, I'm leaving. Your mom wants me to move my car, and I just don't feel like being here, so I'm leaving." He tried to stop her. The testimony also was that there were times, because it's not court order, there's nothing with regard to parenting time, that Mr. Stark doesn't get to see his daughter. So I would submit to the court that that does qualify as extreme emotional distress.
The only thing I would say to that, well, there's a lot of things we could say, but one of the arguments, though, would be almost every case we see that when there's a child involved. It always seems like there's an argument over the child, over visitation, over all of those things. Almost in every domestic violence case, there's some type of extreme emotional distress going on. So wouldn't that mean, I guess what I'm concerned about is that would just be almost in every situation like this, every time a charge like this.
I would submit that the distinction turns on the parenting time, and not that there's a child involved, that it's a conflict between parents. I understand the court's point that in these situations there is emotions running high, and it's a fight, it's an argument. Domestic violence or assault is alleged, knowingly causing or attempting to cause physical harm. But I would submit that the distinction is with the withholding of the parenting time, not having anything through the court, and
But that's that's your client's responsibility to go to court to establish that parenting time. He can't take matters into his own hands.
that's true. That's true, Your Honor. it could be different. There could be extenuating circumstances about why that's done or why it's not done based on the relationship of the parents, or it could be financial, could be other reasons. But I would continue to submit that based on the facts in this case, the testimony in this matter, that the element with regard to allowing this testimony to come in under the extreme emotional distress with the provocation is met. So
So the law says from reasonable provocation, as opposed to, I guess, from unreasonable provocation. Is your argument that that means that a reasonable person would have reacted the way the client reacted when faced with that situation? It doesn't say it's reasonable that you are extremely emotionally distressed over the situation. It says a reasonable provocation.
right, I think that, I guess just the way I took it was reasonable provocation, that the person who is alleging this extreme emotional distress has been provoked. I'm not quite sure how the reasonableness fits in there. I guess is that what we're saying, that it's reasonable that someone was provoked?
I'm just trying to understand because that's the basis of that argument, I think, that you're arguing for. So I just want to more clearly understand what your argument is.
Well, my argument is that certainly it's provocation to say, based on the facts that someone's going to leave, not let you see your child after this has all been set up and this is your expectation. I sort of took it as the reasonableness is kind of applying to actions on the victim. So I do think it needs to be fleshed out and explored more, because it is cited in the decisions from this court. And obviously the state focused more on the self-defense part, but this is part of that. And so
Are we going to find that the record below indicates that the extreme emotional distress from reasonable provocation was argued to the trial court?
no, I don't think that was argued. I suppose it was just sort of inferred from the testimony, but I don't think that specific point was argued in the record in the court below. It was a little bit confusing. I mean, my position is that trial counsel did object, did proffer the testimony, volume 2, page 105, when they're sort of talking about these issues. It's a little bit unclear exactly what the specific argument was. It wasn't really a specific argument based on, the case law, these cases from the 9th District. Evidence Rule 404A2 was referenced.
With that too, would a defendant have to admit he engaged in the conduct? Because that could be a little inconsistent with different defenses, obviously. Because obviously where we see it usually is in jury instructions with reasonable provocation and so forth, and with self-defense.
Right, that's what I'm thinking. It is sort of, since it's part of like self-defense or extreme emotional distress, it is sort of akin to self-defense. So
It seems almost like you would have to admittedly engage in that conduct, that's what I'm wondering. But he was justified some way, and that's when they would come in with her, tendencies or whatever.
I think that's right. I think that makes sense.
So that could be a problem as well. You only have to go with what you have on the record, I understand that. We're just trying to, like you said, to flesh it out in regard to what, if not for this case, for all the cases in the future.
Yes, I think that's true. my position is that that's the most important issue, I think, that we're asking the court to look at. Certainly, I don't concede the other issues, obviously, they're much more difficult. Second issue that we raised is, of course, the manifest weight issue. As I said, I don't concede that. I would argue this is one of those unusual cases, extreme cases where the jury has lost their way, and part of it might be because of the evidentiary issues, and part of it's just based on the testimony, the conflicts in the testimony, some of the physical evidence with regard to the dog jumping around and the scratches, but no finger marks testified to by Deputy Copenhaver. So we'd still be asking the court to consider.
I was just wondering, I got a little confused with the brief. You're not suggesting that the dog scratched her throat. You're saying she was just so worked up and started getting all red and blotchy because of all the, or are you suggesting that the dog scratched her throat?
That's what I took from the transcript in the trial testimony, that the dog does get upset when there's arguments going on and these things going on, and so that the dog was jumping around, and that was part of what happened.
But she had to be laying down or somehow for the dog to get to her throat.
So that's the main arguments I wanted to address with the court. So we are asking for the court to consider that evidentiary issue. As the court's already suggested, I think it would be beneficial for counsel and for the case law to sort of perhaps tighten up that, the Stringfield and the Homini cases, what that means with the extreme emotional distress and the exact parameters of that. But we are asking the court to find that testimony should have been admitted.